Welcome, everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association. And we're very happy to have this program for you today about some new legislation that's going to be important for a lot of construction projects. Before I do the introductions for this, I want to let you all know about our upcoming programs for this section. Uh, Next week on Thursday, February 26th, we're doing a real property tax program. We have Chris O'Neill and Ruben Sissian of the Greenberg Traurig firm presenting. They're going to talk about a subject that we really haven't done before when it comes to property taxes. They're going to talk about how you recover attorney's fees in tax proceedings. Chris has litigated all the way up through the California Supreme Court, certainly some cases probably that involve public policy, and it'll be interesting to hear if and when they've been able to recover attorney's fees. And they're also going to give an update on what's going on at the State Board of Equalization regarding property taxes. In March, we have our annual California Association of Realtors, that's the CAR, update on their new and revised forms. And Jana Gardner is joining us again for what is always a very interesting program to find out what's new on the residential purchase agreements. In April, we have Howard Fisher, longtime volunteer with the Beverly Hills Bar, former president, talking about 1031 exchanges. April 23, we're doing our annual review of the prior year's real estate cases by Larry Jacobson. We're doing another new program for us on May 21st, which is a program on landlord insurance coverage for habitability claims in landlord-tenant disputes. I'm sure everyone realizes that habitability is a major issue in any landlord-tenant litigation, most landlord-tenant litigation. And the idea that you could get insurance to cover that where these habitability claims comes up is a big issue. And Steve Raucher, also another former officer of the Beverly Hills Bar, is going to give that presentation. Steve is a specialist on insurance. Our June program is going to be Brian Mashin, who many of you know lectures for AIR. He gave lectures the last 2 years for us on their purchase agreement and their lease agreement. And this time we're going to again do a different program. Brian's going to talk about effectively representing the small tenant in negotiating a commercial lease and the nuances and the dynamics when you have a smaller tenant negotiating with the landlord on their commercial lease. Just to remind everyone that for these programs, if you have questions, put them in the Q&A. The chat will have a link to the program materials and some information about the bar, but otherwise, all the Q&A should be put in the Q&A section. So it's my great pleasure to welcome Brenda Radmacher, who's a partner at Seyfarth Shaw, to give our presentation today. Brenda's practice focuses on legal issues affecting landowners, developers, contractors, and design professionals. For nearly 3 decades, Brenda has handled complex construction disputes, and she advises clients nationwide and internationally on all aspects of construction and project delivery, including design build, EPC, and public-private partnerships, with experience in construction defects, insurance issues, payment disputes, and high-stakes infrastructure, energy, and real estate projects. So she's worked on obviously some very substantial projects, and we're looking forward to her in educating us about SB 440. Brenda, welcome and thank you.
Thank you so much, Howard. I really appreciate you and the Beverly Hills Bar Association having us today. My colleague Jay Houghton was on the agenda, and unfortunately he, as a lot of litigators, got called into a last-minute deposition. So I am here and will carry the torch. I'm going to see if I can share my screen and start the slideshow, and we'll jump in. Right, so let's see if I can make it happen. Did it fail to start? Give me a moment. Let's go back. We had it all set and ready to go. And
Looks like it's up.
oops, it's except the wrong slide is on there. So let me do one more. Sorry about that. There we go. All right. Now can you see it?
Yes.
Great. Well, I'm gonna go through. You already did a great job of giving us a an overview of what we're going to be doing. We always like to start with a disclaimer that this is not intended for legal advice, but I'm happy to answer as many questions as the audience has in the Q&A as we go along. I do want to give you an overview of what we're going to cover because I like people to know where we're going. So we're going to start. I'm going to give a background and some overview about this new statute. We're going to talk about the historical context, how we got to where we are. Then I'm going to dig into some of the meat. We're going to talk about what the statute is, what the requirements are, some enforcement provisions. We're going to look at the protections for subcontractors as well, because it's a little bit of a subsection about what's happening in the statute. And then we're going to do some talk and look at some practical things that hopefully the audience can really take and use to implement what the statute's going to be requiring, having an understanding that, and then close out the time with looking at some of the uncertainties that the statute has now presented, as well as some of the risks that may apply both to owners, developers, contractors, and subcontractors all involved in the construction project. So let's start with and jumping in on an overview. First off is this law is started as SB 440, and it's called, the title of the act that it may be cited as is the Private Works Change Order Fair Payment Act. And as we'll see as we get into this, it's a bit of a misnomer of the law. I may refer to it as the Fair Payment Act as we go along for short. But you know how these things go. When we have a statute, we oftentimes call it by its bill number. So SB 440 is also how we may refer to it for short. So SB 440 is statutes that is effective on new construction contracts that are as of January 1st, 2026. And as we'll see, the law is a little bit unclear as what does that mean if you have a multi-phased project and what happens there. It is currently scheduled to sunset January 1st, 2030. So we are at a 4-year period of time to see how this plays out and what goes on. For those of you following along in the statutes, California Civil Code is 850 and 851 is the Private Works Change Order Fair Payment Act. And it has a very narrow focus on private construction projects. There's some things we're going to talk about a little bit of. There's a similar statute that was passed 10 years ago that was governing public works projects, and we can talk a little bit of the comparison is interesting. Now, what we do have on SB 440, it governs any and all disputed contractor time and payment claims. As you remember, I said it's a bit of a misnomer saying it's change orders. It's interesting because the initial part of the statute seems to have developed out of disputes arising on construction projects that relate to change orders. So, who's responsible for the change order? Is it an owner-driven issue? Is it a contractor-driven issue? Is it a design issue? Why has this change order occurred? Is there some type of a issue that was, unknown at the time, a hidden condition or the like? However, as the statute, as you dig into it, it actually very specifically applies not only to change orders, but in fact to any disputed payment amount between the contractor and the owner, as well as disputes over delays and time. And as I like to say in construction, people ask, what are construction lawyers and why is there a whole area of construction law? I said, well, in construction, there's 2 issues, it's time and money. And this statute for private projects applies to both. The statute is now, it expressly states that it's mandatory and non-waivable. There are some portions of some of the implementation that the parties can negotiate and can skip through a few of the hurdles, but it is a non-waivable, and it would be found to be against public policy if parties try to contract around the requirements under the Act. And interestingly, and probably most importantly, there are significant financial consequences imposed by the statute for failure to comply, and we'll talk about that. So let me give you a bit of historical context and background on the reason why we have this law. And it's very interesting in Section 8850, Section A, it states two reasons, for this statute. One is that it's in the best interest of all the citizens of the state of California, as well as for the parties, to ensure that all construction business performed on private works in the state are complete and are not in dispute, is paid in full and in a timely manner. So this was the number one. They're like, look, we have a rampant issue where construction work that's done, that's complete, is either not paid in full or not paid timely. And that the reason behind that is that there is substantial, significant financial hardships on communities and on the construction contractors, and particularly small businesses and minority and disabled veteran business owned contractors is the statute's underlying. And historically, there has been in the construction industry, the subcontractors are usually the parties that are bearing the brunt of some of the payment disputes, even if it might be just between the owner and the general contractor. And as we'll talk about a little bit, the genesis of this statute really does seem to have come in large part from the construction and subcontractor interest groups and lobbies. We are seeing that also when there are disputes on payments, particularly, and delay claims, they often do require extensive litigation that can last for years. And so then if you have this position where parties aren't being paid and work might have been done and was owed, there's a substantial impact that's reducing the number of contractors who are staying in business. And so the legislature found that this was something important and that they thought would be useful. The Senate Judiciary's analysis actually noted that because change orders oftentimes were informal or not fully documented or maybe not executed during the middle of a construction project, that there were late or partial payment issues that contractors were suffering and or that they weren't being meaningfully addressed until the end of the project, which under the Senate Judiciary's analysis was leading to extensive and expensive litigation without having any structure. And so that the statute was intended to provide some structure for dispute resolution to make things more efficient in the private sector. And the sponsor, Southern California Association of Scaffold Contractors, was one of the sponsors that was cited in the Senate floor analyses in the historical underlying for the statute being impacted, and talking about power imbalances. And as we'll see, a lot of times we say, well, is there really a power imbalance when you've got maybe a homeowner and a contractor? Maybe a very different situation than when you have a multi-facility owner developer and a contractor. And the statute actually does try to address some of those issues. This SB 8440 framework has been inspired, as I mentioned, by laws governing the public work projects, dispute resolution on payments, and you are all welcome to reference and read through Public Contracts Code Section 9204. And as I mentioned, that statute passed just under 10 years ago, is enacted in 2017, and will sunset if it's not extended the end of this year. As of right now, we aren't seeing any issues of whether it will be extended or not. That has not yet been passed through, but we're keeping an eye on that. Under the public contracts section and statute, there is not a mandatory pass-through of subcontractor claims for a prime contractor. So they may, under the statute, under section 9204, they may pass through a claim to an owner, but they're not required to. And under Section 9204, there is a maximum of 7% interest annually on payments that are not paid timely under the statute's requirements. Keep that in mind as we go through and talk now about SESB 440, and again, Section 8850 and 8851 are, you'll see some differences and we can do some comparisons. Now, the law covers, as I mentioned, all private construction projects, but there are some limitations. The exceptions, it does not apply to residential projects that are under 5 stories that are not mixed use. So if you have a mixed use project, maybe your first floor has some commercial, you have only 2 floors that are residential, the statute would apply. However, if it is solely residential under 5 stories, the statute does not apply, and parties are free to try to negotiate and obtain payments and deal with those on their own. Now, this statute also, it governs not only owner general contractor disputes, but it governs also any subcontractor demands. It covers, as I mentioned, not just change orders, but it covers time extensions, including liquidated damages, and also for payment for work under the contract. And this is it's interesting. It's a quote here of not otherwise provided for or to which claimant is entitled. And the statute doesn't define exactly what that means, but the best interpretation that we've been able to determine is essentially it's any disputed payment amount or payment issue that for work performed by the contractor. And finally, it covers amounts disputed by the owner. So the owner may look at a change order or a payment request from a contractor and dispute that it was accurate or complied with the terms of the contract or the rates agreed upon, and that would also fall under what this statute covers. So let's look a little bit at some of the key requirements under SB 440. And there's a couple of slides here because there's quite a number of requirements. And before I'm going to give you kind of a thing, is really the way that the statute is, there's really 3 sections of what parties are going to have to do. The first section is a claims process. So you've got a claim being made. The second phase of that is going to be where there is an informal conference or a meet and confer requirement to be addressed to payment disputes and or time disputes. And then the third section is a required mediation. So we've got a 3-step process, and here are some of these requirements, and we'll walk through them a little bit. So the first issue is the contractor has a claim. The claim has to be submitted. Everything under the statute for communications by the parties, when we say it has to be submitted, it has to be done registered mail or certified mail or some form of mailing with a return receipt requested. So when we say it's being submitted, that's what I mean every time: certified mail, registered mail, return receipt requested. There's nothing in the statute that says the parties couldn't contract to have a different means of communication. So that's an open question, but the notice got to be done, and that's one hurdle. If you don't issue your notices and your claims and your responses with certified registered mail, return receipt requested, it could be deemed that you're in violation of the statute, and we'll see the ramifications. So your claim by the contractor first has to be supported by reasonable documentation. There's no definition of what that requires, so it's up to everybody's interpretation of what would be reasonable to be documented. And that can be done at any point in time during the course of construction, and then the statute and or at the end, and the statute then triggers the next steps. So the next step, the owner responds. So far, so good. So very simple. Claim is made, owner response. Owner has to written response, and that again is certified or registered mail, return receipt requested. And they need to identify if there is any undisputed amount or disputed amounts in the request made by the contractor. That undisputed amount then goes to the next phase. But that timing, as you can see, the owner has 30 days from receipt of the written notice of claim to provide this response. They need to identify the undisputed amounts then if there are undisputed amounts, those need to be paid within 60 days of the issuance of the response. So you're kind of adding in, you've got 30 days as an owner to respond, and once you have then another 60 days to pay, so 90 days if anybody's keeping track, to issue that for undisputed. Now, if you have remaining disputed items, you go to the next phase. For the disputed issues, then you have a mandatory meet and confer requirement where the parties meet and confer about the disputed amount. The contractor will then, after receipt of the notice from the owner, as we saw, you get 30 days. Owner says, I agree. Then you've got 30 days. Contractor then can request a meet and confer. Within then that time, if the meet and confer occurs, the owner then can notify and has 10 days to notify about any remaining disputed amount, with the hope that during that meet and confer, there is agreement and resolution that all the issues, there's no more disputed amounts, they've been agreed upon. And if for each time there's an agreed upon amount, undisputed, the owner has 60 days to pay that amount from that time. So we'll go through an example on that. But then you say, what happens next? We still have undisputed amounts. We may have gone down this, and we keep trying to, in a sense, whittle it down. So now we have remaining disputed amounts. And within the 10 days, owner sends that notice. The parties then, after receiving that notice, have another 10 days to agree upon a mediator. If the parties can't agree upon a mediator, the contractor has the right to select one and commence that mediation process. The mediation is mandatory, non-binding, and there is not a time frame under the statute that the mediation must occur, with the assumption that the parties have agreed, they've got a mediator, and then they work with the mediator to schedule the time for the mediation. If there are still remaining disputed items or the mediation process is not successful in resolving all issues, then the parties can proceed either with their arbitration or litigation proceeding as provided for as their dispute resolution process under the contract. So it's a lot, and there's a lot of moving parts, as you can see. Now,
Brenda,
yeah, go ahead.
I have a question.
Yeah.
I've always questioned the right of, for example, a court to force somebody to go pay a private mediator, and there's no mediator panel set up for this. Do you think this is going to be subject to some challenge where somebody says, you know, they don't have a right to force me to go basically to some other proceeding besides the court in order that I have to pay for?
Yes, the short answer is yes. We are definitely anticipating that on several levels. However, there may be, you know, well, it'll be very interesting to see sort of how that plays out. Under the statute, the parties can agree mutually to waive either the informal conference or the mediation requirement. So that lies this issue where, well, if the parties agree to waive it, but it still is forcing if one other party won't agree. So I think that is an area ripe for some challenge. We'll see if it actually comes in. Now, the part that's interesting, so as I mentioned, the notices, the registered certified mail is important, but what happens if the owner doesn't respond? You know, so that's always a concern with contractors, is like, hey, we've done the work, the owner has ignored us, or they're refusing to pay, and now we've gone through this process, we've done all the things, we've issued our notices timely, and the owner fails to respond, or the owner fails to timely respond. Either one is deemed expressly under the statute as the entire claim is being denied. And then you can kind of skip through everything and go straight to your dispute resolution process under your contract. Now, as the interesting question, though, is the parties under the statute are supposed to share mediation costs equally. And Howard, as you've raised, is that really, you know, now we've got the legislature forcing people to pay mediator fees for this. So I think that's an area that is a huge question mark as to what's going to happen with that. With the statute applying in large part to, even though they're residential projects, they're more likely to be commercial owners, commercial and larger contractors that are doing these, they may end up saying we'd prefer to participate and spend some money on mediation instead of challenge it, but we will see. Now, the other thing that is interesting is the statute does say you can agree to additional change order or claim dispute resolution requirements as long as they don't eviscerate the procedures and the timing provided in the statute. Again, another ambiguity. So we expect there's, assuming the statute continues and stays in place, that there will be challenges and issues raised about, hey, now the owner has modified the contract, even the parties agree. Is it something that is allowed under the law? So the ambiguity there still exists. Now, I'm going to give you a little visual aid because this was, people are like, how do we deal with this? So I want to walk through like kind of what would happen here if we took a simple example. If you've got a contractor with $1,000 claim, they've got the owner has to respond within 30 days. If the owner in this case says, I agree, I owe you half of it, we don't dispute half. So the undisputed 500, as you see to the right on the chart, owner has 60 days to pay that. Owner pays the 500 in 60 days. That's done. The remaining amount of 500, there's no set deadline under the statute, but the contractor then can request an informal conference, which then triggers the timing from there. So we've got $500. They're going to have 30 days to have an informal conference. There's no guidance as to what that needs to look like in person, by Zoom, a telephone, who needs to be a part of that necessarily. Someone with authority is about all that the statute provides. After the informal conference, 10 days. But Howard, you had a question.
Yeah, Brenda, does this mean that 7% interest provision doesn't apply during those 90 days?
Good question. Now, first I will tell you 7% is 7% annually is under the public statute, under the public contract. But for SB 440, it's a 2% interest per month.
Yeah, that's really a huge amount of interest. Yes,
it is. It can be, that's up to 24% a year. And I've got a whole section on this coming because it's an interesting question of when does that apply. Preview is the undisputed amounts. It's intended, really, it's not called a penalty, it's interest, but it is really intended to try to get parties to agree as early as you can on undisputed amounts. And I know for a lot of the contractors and folks I've represented and owners, a lot of times it's hard to like, well, we don't want to release the undisputed amount because that's our leverage. And, my advice has always been just pay what it is because you're going to have interest potentially due. And this statute really is pushing that. It's like if there is any amount that's undisputed, pay immediately. And if you have disputed amounts, you better be pretty certain that you've got a good basis to not pay as an owner. And because the penalties do start to add up.
One more question.
Yeah, go ahead.
Brenda, is that let's say that you have a dispute with the contractor, but it's not regarding the particular payment they're talking about, but you've discovered some prior work they did that you already paid for that is defective or incomplete, and you want to raise that as a defense to this particular progress payment.
A great question. It's not answered under the statute. And it would be part of that argument that you'd say, hey, we're not paying you for this payment for that reason. And that still the parties are supposed to try to negotiate that in the informal conference or through the mediation. So it doesn't preclude you from making those as arguments and positions as well, and vice versa for the contractor. So if the contractor is claiming this money is owed because there was on a change order basis because the design changed and they needed to, it wasn't called for in the original drawings, and the owner's, the argument from the owner is, no, this was, and you should have seen it or you should have raised it, or there's some other issue that the contractor didn't do. Those issues still are part of this whole negotiation process. It remains to be seen how it all plays out. But assuming you get to the informal conference and there's still no agreement, contractor owner has 10 days from then the contract owner to notify the contractor. In this situation, we said, great, they were able to agree of 50% of the 500 that was remaining disputed. And in that informal conference, then they have another 60 days. So it's a new trigger date from the informal conference if there's agreed upon amounts. And the remaining disputed amounts continue to flow down to the next phase. The owner, after they notify that they still dispute amounts, they have 10 days to then mutually select a mediator, as we talked about. And then again, they can proceed to mediation. If there's no resolution, it goes to the dispute resolution. In your comment and your question, interesting, like there's not a panel of mediators, and I will say yet, to handle these claims. I am on American Arbitration Association's panel of mediator and arbitrator, as a lot of construction lawyers do serve in that role. And I believe that AAA, as well as a variety of the other dispute providers and JAMS and ADR services, are looking at this and trying to say, do we have panelists who are available to serve as, and there may be reduced rates depending on the size of the dispute. So I think that the mediation community is looking at this and is going to be responding to it as well, seeing the need that the statute may be creating. Now, the interesting part of what can the contractor do here? So if the owner fails to pay timely or is paid the undisputed amounts, or if there are adjudicated amounts, so if they do go to an adjudication proceeding, the contractor can suspend work until the payment is made. And this applies, like I said, if they don't respond during the process or on the payment side. So there is a 30-day stop work notice that the contractor is required to issue. And after that, they have a 10-day period they have to wait. So they have to say, hey, we're going to stop work. You've got 10 days to to cure and pay. And if you don't, we then issue a 30-day stop work notice and they can stop in 30 days after that. Again, very little detail in the statute of what that looks like and how that works. So we expect there to be some issues and disputes coming out of that part of the statute as well. And as I mentioned, the 2% interest, and Howard, your question was right on target of, well, when does this commence? And it's 2% per month on each of the unpaid sums from the date it's deemed due and owing. So if the owner agrees and said this is an undisputed amount that is deemed due and owing for the unpaid amounts, and they have 60 days to pay, and if they don't pay within that 60-day period, then our interpretation is that the interest on the undisputed amounts not paid timely would commence after that 60-day period. For the disputed amounts, as you go through, if it's deemed due and owing, the interpretation is a little bit hard to tell what the statute means, but it does appear to be an argument that if it is disputed and you go through this process, it is not necessarily deemed due and owing until you go through the process. However, I can guarantee you that there also is an argument under the ambiguity in the statute to say it's triggered from day one when the owner rejects and says we find it, we dispute it, and we go through this whole process and we litigate and we find that we do owe the money, that there will be arguments that it was due and owing from the date of claim. So lots of opportunities for disputes and a lot of legal arguments that we think are going to probably be forthcoming. Now, the way the statute's worded and written, it is discussing obligations and requirements between the contractor and the owner. There is a subsection that does address subcontractors and what happens to the subcontractors. And as we started, it's interestingly because the majority of the underlying historical context was trying to bring and protect some of the subcontractors. So you have a subcontractor who's deemed to have no contractual privity with the owner, but they are allowed to submit their own written requests for themselves or a lower tier. And again, certified mail return or registered mail return receipt requested. And they have to submit that to the prime contractor to submit to the owner as a pass-through. The subcontractor under the statute has to do this quote unquote timely and provide reasonable supporting documentation, neither of which are defined. So, is timely 30 days? I don't know. Is it 60 days? Is it we're not sure. So timely, and my recommendation, do it as soon as there is an issue on payment. Get it going and provide the backup as to why it was built, what the work was done, and it was billed. And then under SB 440, the subcontractor, if they're submitting a claim, has to cooperate with the contractor through this dispute resolution process. And again, it doesn't really tell us what that cooperation looks like. And, that may lead to some disputes between the contractors and the subcontractors as, hey, I'm going to pass through your claim, but you got to do X, Y, and Z. And the sub says, I don't have to. So we'll see where that ends up going. But within this process, so what happens is the subcontractor makes a request. The contractor has an obligation to respond in writing to the subcontractor and tell them if they're submitting the claim to the owner or not. They're not obligated to submit it, but they are obligated to respond to the subcontractor to identify in writing why they are not submitting it to the owner. The only requirement that the statute provides is the contractor has to act in good faith. Again, not defined. And finally, if they are going to negotiate and go through the process with the owner, a contractor cannot settle the subcontractor's claim without written approval from the subcontractor. Lots of layers in this, and as we saw, it's a kind of a truncated time frame. So if you've got 10 days to agree upon the mediator, subcontractor under the statute doesn't have a right to demand or select that mediator. But do they, you can go through that as the contractor, the prime contractor with the owner, negotiate, but you got to get the approval in writing from the subcontractor. In my mind, does that subcontractor then have to be in the mediation? And Howard, to your question, is the subcontractor now having to pay a portion of the mediation fees? So lots of different moving parts as to what the subcontractor protections and requirements are going to be. And again, the statute it's a pretty short statute, pretty quick read, and there's not a lot of detail in that.
I'm also wondering, Brenda, does this somehow create an obligation from an owner to a subcontractor they're not in privity with? And does like the 2% a month apply to these sorts of claims?
So the claim technically is, because it's a pass-through claim, it's coming, to the contractor. So the 2% would still be owed, but it would be owed to the contractor. So I don't see it as creating any other obligations out of privity because it is going through the chain, kind of, so to speak, of command.
Aren't there possible problems with the subcontractor's agreement with the contractor doesn't really align with the progress payments the contractor's entitled to get?
Very, very true. Yes. And also, one of the areas that we see as problematic is that if it's creating sort of these two routes and two timings. And it does behoove owners to be asking their contractors to see the subcontract agreements and understand what their negotiation and their payment process is with their subcontractors because of those issues.
One would think that might be part of the documentation that the contractor has to supply with the claim. Otherwise, the claim is incomplete.
Right. Yeah. And again, because it's ambiguous as to what needs to be included other than reasonable backup and reasonable documentation, it's an open question. And because it applies also to delay claims and not just payment disputes, it's the easy way, and the way the statute is written is really focusing on dollars. But the interesting question is, if you've got a payment delay issue or a scheduled delay on the project, still is going to be an issue. And how do you evaluate that? And what portion of it's disputed or not? So there's some issues that's brought up.
It seems problematic because a lot of times the contractor may already have had issues with the subcontractor. That's why they haven't paid them. It
Right.
isn't really the owner's fault because there's defective work, there's been delay by the subcontractor. They may even have a dispute between themselves on another job.
Yep.
And all of a sudden the owner is injected into this dispute that doesn't really involve them.
I would say not necessarily, though, because what the statute does provide is it doesn't require the contractor to pass through the subcontractor's claim. So the contractor can respond to the subcontractor in a situation like you've raised and say, I'm not passing this claim through because you haven't performed or you have these other issues or whatever those claims may be. They just have to put that in writing and send it to the subcontractor. So that helps, I think, a little bit in that regard, and it's not really putting the owner in that difficult position in those types of circumstances. The implementation, this is what we're encouraging everyone in the construction industry to do, whether you're council, whether you're a contractor, you're an owner developer, you're a subcontractor, whether, construction project managers as well need to be aware of these as we're looking at contracts and negotiating, is understanding and reviewing the timelines. We are really recommending is setting up calendar alerts. So figuring out and really adjusting your payment schedule if you're an owner and a contractor for your subcontractors, being sure you're tracking the payment timing, looking at any tracking software that you're currently using, and evaluating if those need to be updated. In addition, having documentation standards within your organization to be understood so that not only what your payment request protocols are, but what documentation is being provided. And developing this, the best thing I say is developing a notice template, because the time is short of how you've got to respond, and particularly for owners. And it is, if you don't respond timely throughout this process each time, you then can, it gets cut off, and then they can go, the dispute resolution process proceeds under the contract, and your ability to collect interest, or to fight that becomes problematic. So a notice template that can be used by your team is something really important. And one issue we've looked at is if you're going to agree upon that, one way about coming about this is that the parties say we're going to agree to mediation, even though the statute requires it, putting it in the contracts, agreeing to it, and having a pre-selected mediator or a process for selecting a neutral to serve as the mediator. We do expect there to be an increase in mid-construction mediations as a result of this, assuming the statute stays in place. And as we talked about, probably more mediators getting into the fray, so to speak, trying to help parties resolve. Looked at this a little bit from the owner's perspective and the contractor's perspective. Owners really need to take a look at their contracts and update them if your processes and procedures and payment request application and payment timing doesn't comply with the law. We are recommending to update that contract, as well as implementing your claim management systems to have a planned response, and training your staff to do so. So people need to be on top of it as part of project management, from the owner's perspective, knowing what's coming and going and having a good documentation process for that. A really easy example of a way to solve is, hire a reputable contractor and really check people's records and know what you're getting into. And you still do have the right as an owner to trigger your contractual rights to withhold payment under appropriate situations. So this isn't saying you just got to pay people, but documenting it is really important, and complying with your contractual or entitlement rights to withhold payment is going to be very important, because that will be part of that process that you can use. And being aware of cash flow considerations, because I know a lot of owners have had their own different payment processes, and this has got to be something now folded into your cash flow. One of the issues that the statute doesn't talk about is how this new law interacts with the Prompt Payment Act. And that's another area that is unclear, but what it does do is it runs parallel. So there is a potential that if owners aren't paying promptly, they are subject not only to the Private Works Change Order Fair Payment Act, but also the Prompt Payment Act itself. And then for contractors, we've got a bunch of action items for you as well. So again, coming up with some good internal processes, including template letters for your claims, making sure you have somebody who is going to be sending the notices certified register or registered mail return receipt requested, and also responding to your subcontractors. You've got that timeliness requirement as well. Educating your teams and your accounting teams is really important for the contractor. Thinking also again about some type of a mediator that you would agree to if you do, and looking at your contracts for continuity between what you're contracting with your owner, as well as what maybe your template of your standard subcontract agreement may be. You've got to make sure those marry together, and thinking through your dispute resolution process and provisions. One of the areas that a lot of construction contracts are, if are have limitations on, people don't spend a lot of time of drafting their dispute resolution process and their provisions in their contracts, because everybody, when you're negotiating agreements, says they're never going to have a problem, we're going to always get along. And we really recommend looking closely and having a dispute resolution process built in carefully into your agreement. And this law is actually going to help push that as well.
Brenda, going back
Yep.
for a moment just to the owner's considerations and action items, what do you see any interplay or anything that the owner needs to put in the contract that takes into account their agreement with their construction lender? And what's the construction lender's interplay with these requirements under this statute?
So there's nothing direct for the lender, but the lender, really would not be, I would say, a consideration with what the owner agreements with the lender is, and understanding that's where that cash flow consideration comes in. Because if you are looking at payment requests, and that maybe you're thinking, with the lender, with the understanding that this was going to be at the end of the job, that you would have issues, or different timing, you've got to look carefully at that. But the statute itself doesn't really pull the lender in directly.
I was thinking more in the case where the lender goes out and they do an inspection and say, we're not going to give you the payment you want because we don't think it's done. I guess the owner would just put that in his response as to why they're not paying, because our construction lender won't pay us and their inspection shows you haven't really fulfilled everything you need to for this progress payment.
Right. And that's pretty good for support for having a disputed payment claim. We do see that there is a potential for the contractors or subcontractors, not all of them, but some folks who might try to take advantage of this process and to use it somewhat as a sword, as opposed to a shield. And that, that's where owners are going to really need to be careful of. If they have a dispute, you've got to document it. And if you have a lender, exactly what you're talking about, Howard, then having that backup from the lender is going to support you if you can't, you go through, and you've got to, you'll have a defense to those arguments that those were not meritorious
I
claims.
suppose the owner could write it into the contract and the contractor would have trouble refusing it, to simply say that we don't owe a progress payment if our lender has inspected and found that the work hasn't been accomplished sufficiently for them to advance the money to us to make the payment.
Yes, yeah. And a lot of the contracts I see do contain that as a standard provision. So, great question. I love all your questions. You got good ones. So our next section, last section, is on uncertainties and risks. And I've alluded to several of them, but we do see this issue, and I talked about it really quickly, is the right to stop work related to these disputed payments. And if you going through the process, and as we looked at that sample, you've got this really interesting issue of, can the contractor really utilize this stop work as an option on disputed amounts or issues? And like you just raised, like, well, do they have a good faith basis for that dispute? And then is the owner now going to be in a position where you've got a contractor utilizing a threat of stopping work to use as leverage to say, well, just pay me, because it's so much more difficult and much more expensive for the owner when the work actually stops? So you're going to go out and hire a replacement contractor, and then does that kind of unravel into a much larger dispute? So that is an area that is a substantial risk that we do see as a potential of rising out of SB 440. The interest payment issue, as we mentioned, even if you have a good faith dispute, and sometimes, the parties can reasonably disagree in good faith, and then you have to get it adjudicated. And as we all know, for anyone who's done litigation, sometimes you have the right argument and you still lose. And so you may have a good faith dispute, and you may then be subject to interest being paid if you don't pay it. So again, this leverage issue and how much, and the dollar amounts at issue may be a part of it as well. So it is a very much an issue of uncertainty and risk. And I think it goes both ways, also, so that the contractor, if they're somehow think they're, counting on getting interest, it's not that those arguments also go away. So if the contractor, and there's nothing other than the mediation itself, it is the only part of this that's confidential. So all of the notices and responses from the owner, and even the informal meet and confer conference, all would be open to be used as evidence in the dispute process, arbitration, or trial at the end. And so if people aren't acting really in good faith, then that's, that seems to be the way the statute is written, to try to make some common ground. As I mentioned, the uncertainty of the interaction with the 2% prompt payment penalty under the Prompt Payment Act, where you're really looking at some real potential exposures for not paying contractors promptly under either of the statutes. There are, and Howard, you stole my thunder here. We think there's a substantial areas for potential statutory amendments over the course of either through challenges or through amendments that may occur. We've seen this on a couple of the other statutes in the real estate and construction arena, where it comes out and the legislatures are all excited and they thought they did a great job. And then we all look at it and say, what were they thinking? This doesn't work. And what about this? And so we think that, there is a potential. I do know I participate in a lot of different trade organizations. There are several trade groups that are looking at the statute and trying to determine if they're going to be presenting as lobbies to some of the different legislatures to evaluate that. What the other uncertainty is how the industry is going to adapt, and what people may do differently and how they may behave differently as a result. The idea was, hey, contractors should get paid timely for the work that they do and that they've completed appropriately. I don't know that this statute is going to actually get there, but that is sort of the, I think, altruistic hope that people are going to get paid timely when they're doing work, and then narrowing the disputed issues that are being litigated, as opposed to a lot of times in some of these disputes, you see things that they just kind of everything gets thrown in, and it's at the end of the project, and it then trying to unravel what is disputed and what's not. And what the idea is to try to say is, hey, can we narrow at least the scope of the disputes? So it will be very interesting to see how this plays out over the next 6 months or so. I think it's going to take 6 months to a year. And also to the extent anything from SB 440 has on whether or not the Public Works 9204, whether that gets amended or is allowed to sunset, depending on how things are going and challenges here. So with that, I think that brings us to the end, and I don't know if we have some questions or answers in the Q&A.
I don't really have much in the Q&A, but I had one or two other comments. I suppose that if I'm an owner and my lawyer advises me, by the way, there's this 2% a month penalty that you're going to have to pay if in this process under the statute, I'm going to want to come back and say, well, I want to write in the contract a 2% a month penalty if they don't do things timely and if for whatever it's costing me, because that's like 26.82% a year at 2% a month. And it seems, very unfair that it goes only in one direction here. And it seems to me that appears to be a major reason for the statute, because otherwise, a lot of these things really would have been taken care of just by having a well-written construction contract. And
yeah, 100%.
yeah. So it makes one wonder about what the dynamics politically were of the trade groups that were behind this
Oh,
statute.
the part that was the most interesting in digging into the historical portion is there was no opposition, none, zero. This passed unanimously.
Hmm. The one other thing, I guess, which everybody kind of knows anyway, but it puts a little more emphasis on your notice provisions and the addresses and making certain proof that like that, just so you're getting your notices, which is always kind of an issue anyway. But I was surprised that it had
Exactly.
to be only by certified mail. You can't personally deliver. I mean, it seems strange.
It was very interesting. And now there is, I think that the parties would be able to amend that portion to say we're going to agree to email notice if we would like to do so, but you're going to want to make sure that's in your contract.
Yeah, it really seemed a bit archaic in that respect.
Agreed. Agreed. Yeah. 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 So, every now and then we take 3 steps forward and 2 steps backward. But great. Thank you. This is going to be, we may have to come back in a year and tell you how we're seeing this all play out. But any questions, people are welcome to contact me directly, and I'm happy to answer questions or assist however
Have
we
you,
can.
at your office, have you thought about any changes you're planning to put in your construction contracts as a result of the statute?
Yeah, we have. We've been working with clients. The statute was actually passed in October, so we've had some clients that we've been working with already and redrafting some of their contracts. And it kind of depends on who they are and what their role is and what type of projects they're working on. So yeah, we're really working out that, and a lot of it is very dependent on our clients and their approaches to their subcontractors and their contractors.
And I suppose where you really have the big issue is when you have out-of-state parties coming in here who would have no idea that something like this exists in
Yes.
California.
Right, right. Yeah. And and it's interesting. And I think a lot of times, we see this in the construction arena where people use the same contract that they've always used. And, every now and then they go, oh, I haven't updated that in 4 or 5 years. And, if you're doing any development and construction in California, it behooves you to be reviewing your contracts annually and making sure that they're up to date on a variety of aspects. And this is yet one more to add to the checklist.
Well, Brenda, thank you very much. Very interesting to hear a discussion from somebody who's, has really looked at this new statute to tell us what's coming in, and so that people can try to adapt if we can remember all this the next time one of these comes into our office.
Very good. I appreciate the time, and everyone. I hope this is useful and helpful for you and your clients as you are proceeding. And I wish everyone luck, and hopefully this helps resolve some disputes.
Thank you very much.
Great.